SJC 13877, Claire Fitzmaurice et al. Versus City of Quincy et al.
Okay, Attorney Davis.
Good morning, Honors. May it please the Court. My name is Joseph Davis, and I represent the appellants, the City of Quincy, and Mayor Thomas Koch. I'm joined by James Timmons, the City Solicitor, and my colleagues Eric Rosbach and Andrea Butler. Your Honors, firefighters and police officers across the Commonwealth and the country understand the figures of Florian and Michael to symbolize the values of courage and self-sacrifice that they seek to embody in their professions. The City of Quincy does not violate Article 3 of the Declaration of Rights by honoring its first responders with statues of these figures. And that conclusion is confirmed by Article 3's own text, history, and purpose, by this court's precedent, and by the longstanding tradition of similar statues on public property across Massachusetts. And on that last point, as a quick example, on my way into this court's courtroom this morning, I walked by this court's statue of Moses in the Great Hall. Right next door at the Suffolk County Courthouse, there's a depiction of Moses above the main entranceway holding the Ten Commandments. In the Worcester Courthouse, there's another statue of Moses. Why does Moses appear in all of these courthouses?
How many fire departments and police departments in the Commonwealth have statues on the front of the building itself of either St. Florian or St. Michael?
I'm not aware of any others in the Commonwealth, Your Honor.
Right. So that may seem, wouldn't that be part of history and tradition as well? That this would be the first one in the Commonwealth?
Well, Your Honor, I do want to point out that a number of fire departments, the majority of fire departments across the Commonwealth use the Florian cross as part of their symbol.
Okay, but I didn't ask that question. I understand. I saw that in your record that they're badges, but we're talking about these actual religious figures as statues on the front of the buildings, and they're, I take it they're just none others in Massachusetts.
Well, I would dispute that they're religious figures, or at least exclusive.
Okay.
One tension in Becket / the city's argument that I want you to look out for as you watch the hearing is how they try to frame the statues in two different ways at once. They basically try to have the cake and eat it too. They argue that blocking the statues would show unconstitutional hostility towards religion, but also argue that St. Michael and St. Florian are not religious figures, or at least not exclusively. They want to say that they're broader cultural symbols for first responders and not religious symbols. But at the same time, then they look for protection against hostility against religion.
Florian and Michael. Just call them Florian and Michael. I take it that there's not another fire department or police department in the Commonwealth of Massachusetts that has these as statues on the front of the building.
There's the Los Angeles Fire Department, the New York City Fire Department, the Bristol, Connecticut Fire Department, New York City Police Department, Bristol, Connecticut Police Department.
Okay, so none in Massachusetts, and you've come up with 3 out of the probably hundreds of thousands of police and fire department buildings in the country.
Your Honor, I do want to draw...
And I don't mean to quibble about the numbers. I'm just trying to... You started off by saying the history and practice in this Commonwealth. And that piece of it is part of the history and practice, right? This absence.
I think, I'm not sure, Your Honor. I want to draw an analogy, right? Because the reason that the Moses statues are relevant, and there's a number of other statues, obviously we've identified a bunch in our brief, pages 29 through 69 of volume 2 of our appendix. The reason the Moses statues are relevant, I think, is that Moses is obviously...
So what's happening here, it's another theme, is the history and tradition point. That is very important and will be brought up several other times today in the hearing. So this justice is pressing the Becket lawyer, Joe Davis, on the fact that the absence of these statues on government buildings is itself the historical tradition up until this point. And that matters because the Supreme Court cases like Kennedy versus Bremerton, rely heavily on long-standing historical practices and accepted religious expression in public life. In other words, they're saying, oh, we've always done this, we've always had this. But what I would argue is the city, by trying to put up these statues, is not preserving some old civic tradition. It is introducing something entirely new, prominently installing statues of Catholic saints on a municipal public safety building for the first time. So this goes against the idea that there's history and tradition behind these statues.
Together, they represent, I think, nearly 1 million firefighters and police nationwide. And they've come before you and they've told you, like, yes, like the city of Quincy is right about this. These are the symbols that represent us. They have a significance that transcends religious lines, and they really do embody the core virtues that firefighters and police officers seek to display when they go to work every day. And so, I mean, I think that's the reason they would go up on the building.
But rather than zooming out to that, why don't we just focus on this case?
Yes, sir.
So in response to Justice Wolahojan's premise, you said that you would push back on that these are religious symbols or I forget what the phraseology, but if you look at the contract language commissioning the statues, it says St. Michael, the archangel, the patron saint of law enforcement, and St. Florian as protector of the firefighters. So why is that not contemporaneous evidence of a religious purpose or effect?
A couple of reasons, Your Honor. I think the first, most narrow reason is that I don't think the record even reflects where that language came from or who it's really attributed to. So it seems like kind of an odd thing to latch onto to try to delve into the decision maker's heart of hearts or something like that. But
where can folks and should folks go then when it comes to the actual spending of these funds that we approve?
You go straight to the mayor. This is one of those occasions where it's certainly okay for this body, and I think we've tried to make it clear over the course of answering some questions, describing what we've been doing, whether it be in this forum or through the media, that this was ultimately and only the mayor's decision. And that if anyone asks anyone in this body, the response, an okay response is, I had nothing to do with that. Call the mayor. And we're fine with that. He believes in this. He thinks it's the right thing to do. Part of the reason that it happens in this process is for that reason. There is a sense of not exposing this body to something that it had nothing to do with. So in our minds, we're trying our best, and he's tried his best not to expose this body to have to answer questions that you had no role in whatsoever. You were finding out about this with the public.
Well, I appreciate you saying that because I didn't want to say it, but now that you did, we found out when everyone else did, and I got the notification on the Ledger app.
And there's a purpose behind it. It's for that very reason. At the end of the day, if you have a concern, an opinion, support, yay, nay on this, ultimately and only this decision came out of the mayor's office. That's it. It's one place.
Heart of hearts or something like that. But I do want to, I mean, the city is not disputing that those are the names of these figures, or at least how they're often referred to, but I don't think referring to them by common names is really all that dispositive.
Well, it's important because if the idea, and you go back to the amicus briefs that have been filed, if these statutes inspire first responders, and that depends on their traditional roles as protectors of firefighters in the police, is the city asking us to separate the secular kind of professional meaning of that from the religious intersection that gives those symbols their force?
Colo has, the chaplains are giving a prayer or some kind of admonition to start. And we said that was okay, even though it was clearly had a religious component to it. So that's your best argument, right? Not that it's, not that it's secular. I mean, it's a mixture of secular and religious. And Colo seems to struggle pretty intelligently with this, although we've got the lemon stuff. But Colo says we look to history and purpose. Then we can't provide less protection than the feds, so it provided the federal test at the time. So isn't Colo a good starting point for how we go about this And
Absolutely, it is, Your Honor, and you're correct that this court, of course, never disputed that the prayers had a religious nature. They were, prayers delivered by Catholic priests, so that would be almost a nonsensical thing to try to say. I think COLO is binding law. I mean, it's got the lemon stuff, as you say, Your Honor.
it's just I'm trying to figure out what in COLO, because COLO is a pretty comprehensive decision. It doesn't just apply the lemon test, and it provides cautions. It seemed prescient that Lemon was going to have some problems with it. So we start with purpose and history. There's also some sense even in that history evolves in COLO. So isn't COLO where we start with some modifications to Lemon? I'm just trying to figure out the law we're applying here.
Under the first COLO prong, the key question is whether the government's purpose was primarily secular or religious. The plaintiffs and Judge Sullivan appear to view Quincy's purpose as inseparable from the religious identity of the figures in the statues. The city did not commission generic firefighters or police officers. It specifically commissioned St. Michael the Archangel and St. Florian, language that appeared directly in the contract documents to the sculptor, Sergei. From this perspective, honoring first responders may have been part of the motivation, but the city intentionally chose explicitly religious symbols to do so, making the religious component central rather than incidental. The second COLO prong is effect. And that asks what message the display communicates to the public. Plaintiffs argue that a reasonable person approaching government public safety building, the headquarters, would see the statues as an official endorsement of particular religious figures and, by extension, Christianity or Catholicism. And Judge Sullivan appeared persuaded that the placement, the size, the prominence of the statues mattered greatly here, because the figures would stand permanently at the entrance of a safety headquarters. The concern was not merely exposure to religious imagery, but the perception that the government itself was aligning with specific religious traditions in a core civic building. The third COLO prong is entanglement. The entanglement prong examines whether government becomes improperly involved in religious matters. While this was not the centerpiece of the injunction, plaintiffs argue that the city crossed into unconstitutional territory by selecting and elevating sectarian figures, religious figures, as official civic symbols. Perhaps simpler, the use of public money is one of the clearest entanglement concerns. In this case, the plaintiffs would argue that city resources, the city contracting authority, property, taxpayer funds, all that stuff is used to commission and install religious figures as a part of a government building or project. That's entanglement. And the fourth prong is political division, which does not exist in the Lemon case. This is a uniquely Massachusetts concern. So the Lemon test has three prongs. This is a fourth prong that only exists in COLO, and political divisiveness along religious lines is uniquely important. The Massachusetts law is uniquely concerned with this. So the plaintiffs argue the controversy itself demonstrates exactly why Article 3 exists, to prevent religion from becoming a source of civic strife and insider versus outsider politics. The lawsuits and all the backlash and Facebook groups, whatnot, all become evidence that the statues are generating religious conflict within the community. And Judge Sullivan appeared to view this as a serious constitutional concern, given Massachusetts' historical sensitivity to these types of disputes and government favoritism towards particular faith tradition.
Yes, Your Honor. We've proposed text, history, and purpose, which is this court's ordinary methodology when it's interpreting the Constitution. But I think COLO is fully consistent with that. And I agree with you, Your Honor. I think you could track COLO up and down. So where does COLO start? It talks about, what was the First Amendment, and then also the provisions of the Massachusetts Constitution. What are the kinds of things that they had in mind? What were the abuses that were going on at the time? Here, I don't think the plaintiffs have identified a single example of sort of religious imagery or mixed imagery that was on anybody's mind at the time that Article 3 was.
Your articulation of text, history, and purpose frightens me, and it seems Bruin-like. Is that what you're proposing, that we go?
No, Your Honor, I talked about it.
Distinguish your text, history, and purpose from what SCOTUS has done in Bruin.
Okay, so when they're referencing a Bruin-like approach, what they're talking about is a case, New York State Rifle and Pistol Association versus Bruin. The U.S. Supreme Court gun rights case emphasized constitutional analysis based on history and tradition. We spoke about that earlier. In practical terms, the justice was asking whether the court should evaluate the Quincy statue's case the same way modern federal courts increasingly evaluate Second Amendment and religion cases, by looking at whether similar practices were historically accepted in public life, rather than applying balancing tests like Lemon v. Kurtzman. So, in other words, should we decide this case primarily by looking at historical analogies and longstanding traditions instead of using the old multi-factor constitutional tests like we see in Lemon and Colo?
It's not Bruin-like, Your Honor. It's Barron versus Kalinda-like.
So Barron v. Kalinda was a free speech case where the Massachusetts Supreme Judicial Court emphasized that mass courts don't always have to follow the U.S. Supreme Court methodology when interpreting the Massachusetts Constitution. Instead, the SJC said it can look more broadly at constitutional texts, history and purpose, and mass traditions. That became important here when Joe Davis from Becket pushed back on a justice's suggestion of using a more rigid Bruin-like approach, history and tradition framework. Davis instead pointed to Barron v. Kalinda as the better model, but I think that's interesting, and it's another one of these them wanting to have it both ways, because Becket would likely benefit if the SJC followed the modern U.S. Supreme Court more religious-friendly direction. At the same time, they may not want the court to rely too heavily on strict historical analysis, because Quincy does not have a long tradition of displaying Catholic saints on government buildings, as we talked about earlier.
Is there an element of preferring one religion here that we should be concerned about?
No, Your Honor, there is not. And that's true not only because these figures...
Why not? Because these are two Catholic symbols. Does that heighten our attentiveness to this?
Well, Your Honor, they're not only Catholic symbols. I think that's quite a...
They're not only, but they're, at least originally, they're saints because the Catholic Church made them saints, right?
I think within the, so I won't keep pushing my points about their broader significance. I'll talk about within the world of religion, right? What you actually have before you also, briefs from the Muslim perspective, from a Jewish perspective, from a Russian Orthodox perspective, saying that we also care about these figures. I mean, Florian is a figure of history who, the legend says he put out a fire. So it should be not all that surprising that firefighters would think that this is a...
But the fact that there are more religions doesn't seem, who recognize these as religious figures doesn't seem to me to advance the notion that they're more secular.
Right, I was trying to distinguish between those two different ideas.
Right, so it's like, it's even more religious doesn't make it even more secular.
No, I would say both are true, Your Honor. These figures have a mixed significance, a broader significance than just a religious significance. They've come to represent firefighters and police officers, whatever their beliefs or background. But even if you focus on the religious part of their significance, which we've we haven't disputed that some people might view them as religious. Even within that narrower focus, they're not exclusively essential.
If this is, the police department and the fire department headquarters are places that will provide necessary public services. And so the citizens of Quincy will need to use that building, will need to have access to that building. And in that context, why doesn't it heighten our concern about this government speech that's embodied in the two statues?
I don't think it differentiates this building from courthouses, for example, which of course citizens need to use. And I do want to say, I think this would be a significantly different case, obviously, if there was some allegation of differential treatment based on anybody's beliefs.
Well, this is a problem for you because downstairs there are 18 or 16 statues. Moses is one. And they're all law related. So that there's a context. But these are going to be the only two statues.
Well, I mean, I wouldn't say that's invariably, so you're right about the Great Hall, of course, Your Honor. I don't think that's invariably true. The Worcester County Courthouse, I think it's more of the standalone variety. But I think the context that matters here is that this is the fire and police building, and these are the figures that represent firefighters and police officers. So if these figures were put in, a more random location, I could see how that would be troubling. But I mean, as I said, the 1 million firefighters and police officers are coming into this court and affirming that we represent people of all faiths and none, and these are the figures that embody the virtues they seek to display.
So when Mr. Davis points out that 1 million firefighters and police officers identify with these figures, that doesn't really fully answer the concern of the justice. The question is not just how first responders experience the statues. The question is also how ordinary residents, especially people outside those religious traditions, experience them when they show up to use the building that they have no choice but to use. This is not a police union hall or a firefighter memorial. It's a taxpayer-funded public safety building that exists to serve the entire community. And the statues are not being placed at some private employee entrance. They're being placed prominently at the public entrance where residents will walk in to report crimes or seek assistance or access services. So I feel like Mr. Davis is not really addressing the concern. I feel like he might be stepping around it a little bit, and I think partially it's because he doesn't really have, this is not their strongest part of the case, in my opinion. I think this is actually one of the core concerns that comes about and is the purpose of the lawsuit, really. I think this is getting at the heart of what is wrong, is when these statues were chosen, they weren't chosen with the public in mind. They were chosen just with the police and fire departments in mind.
We're here on a review of the preliminary injunction. And you're, you in the Lemon test or Colo test, the first is the secular purpose, but here the judge found that the purpose was not secular. What do we do with that in light of our limited role in reviewing the preliminary injunction?
No, I think that's an important question, but the
I thought so.
Yeah, the judge. The judge, I think he didn't actually make a fact finding about what was the purpose behind these statues.
Didn't believe the mayor.
He didn't believe the mayor,
and used McCarthy's statement,
which we find troubling. We have a sworn affidavit, of course, that has never been crossed.
Was there an evidentiary hearing, or it's all done on documents, right?
It's all done on documents. The plaintiffs didn't ask to cross-examine the mayor. But I want to focus on what the Superior Court did say, which is that basically based on the religious nature of these statues is how he put it, that they lacked a secular purpose. And I think that's a legal argument that's squarely contrary to Colo. I mean, what Colo explicitly says, these prayers have a religious nature. Of course they do, right?
No, don't we defer to his finding of a likelihood of success on the merits for PI?
Not if it's based on a legal error, Your Honor. I mean, if it's based on a legal error, that's per se an abuse of discretion that's justified vacating the preliminary injunction. And I do think it's a legal error under COLA because, again, COLA says there are secular purposes to legislative prayer generally. It's not like what was going on in the legislators' hearts that crafted the legislative chaplaincy statute. It was these prayers serve to solemnize government proceedings. And it's a highly analogous purpose to the one served by these statutes. They serve to solemnize.
You're saying it's a legal error, but what Judge Sullivan ultimately says is, I discredit the mayor's affidavit.
He doesn't say that, does he?
Well, at least as to the part about what the basis was for the religious basis for choosing the statute.
I don't think he says that, Your Honor. But even if he did, our point is that
he said his statement is self-serving, right? He didn't say he didn't believe him. He said it was. I don't know what, we're in the same position to evaluate those affidavits. Justice Gaziano's question is a good one. How do we analyze reasonable likelihood when it's on documents?
You're in exactly the same position that the Superior Court was in to evaluate this affidavit. It's not like he was making a credibility determination based on having seen the witness or something like that.
Our case law would suggest otherwise.
Well,
that trial judges do get to pass on the credibility of affidavits, and we say this in the context of motions for new trial all the time, that self-serving, he doesn't have to credit that. But let me ask you more.
So something I wanted to bring up, because I found it interesting, is way back in the fall when I read the judge's decision, I read self-serving differently. I thought self-serving just meant like, hey, I don't think you're being completely honest with me here, which is sort of what it meant, but not exactly. It's not any kind of comment on Mayor Koch's character. What it is a technical term in legal settings, which I didn't know. Self-serving basically means that the affidavit was kind of crafted to support their legal position, and so the judge is allowed to make that determination, So in this case, it looks like the judge weighed Mayor Koch's affidavit against the contemporaneous evidence, like Counselor McCarthy's statement, like the language that was on the work order for the sculptor, and probably other public statements. And if they read AJQ, well, I know they didn't because it's not in the court record, but I found like there was a lot of evidence that religion, then the mayor's religious beliefs were at the heart of this decision. That was my personal determination, and I wrote about it, and I put up evidence supporting what I felt. And so I think the judge did his version of that too, and the ACLU did their version of what I did. They put together some evidence, and so when they say self-serving, it doesn't mean exactly the way you'd mean it in like a casual, non-legal conversation. It has a technical meaning to it, which is what they're discussing now. And so I wanted to point that out because I found that very interesting.
A more pointed question about that.
Yes, sure.
Aside from what you filed in front of Judge Sullivan with the mayor's affidavit, was there any other evidence that was presented to Judge Sullivan in making that determination about whether the city considered any other non-religious alternatives or selected these figures through some kind of public process rather than them just being the patron saints of firefighters and the police?
The evidence as to the mayor's purpose and thinking was totally one-sided at the Superior Court. His evidence, or his contemporaneous statements before the affidavit were exactly the same as what he said in the affidavit. Mm-hmm. We had the firefighters and the police. His point was, I'm putting these up for the firefighters and the police officers because these are symbols that represent them. And then you had the firefighters and the police officers come into the case, try to intervene and say, yes, he's right. These symbols represent us. So it really is.
But there's also the clandestine nature of what the mayor did. And that figured into Judge Sullivan's analysis that it wasn't done publicly. It was done sort of secretly.
Well, I mean, we would dispute that. Those adjectives, obviously, Your Honor. I mean,
Clandestine's not accurate?
well, it was done, I mean, I guess that sort of has a connotation to it that, I mean, it was done late in the process because this building was built according to the construction manager at risk process, the whole point of which is to allow flexibility. So there's no doubt that, the mayor testified, it was as we were finalizing the facade of the building that we realized there's room in the budget, we like public art, and we'd like to put some public art.
Any precedent for a major piece of public art being done like this? Usually there's tons of process, right? Art is controversial in general, right? People have strong views. That's got to be a factor to consider, isn't it?
I mean, if you had a procedural claim, something like that would be a different case. It might be a really interesting case, but I'm not.
This part really surprised me, and I was kind of excited about it because I wasn't expecting them to focus on this. But a surprising part of the hearing was how much attention the justices gave to the procurement and selection process behind the statues. Because that might sound like a side issue, but to the people of Quincy, it was not. It was a really intense issue. In fact, I'd say the people that were opposed to the statues fell into one of three camps. One, their objections over the religious nature of the statues, a church and state issue. Two, a internal controls issue where these were bought with no public process, where the only reason people knew about it was because someone leaked it to the press. And three, the third camp is the people that felt both pretty strongly. And I know all these people. I know people who their main objection and concern was the constitutionality. A lot of people were more concerned about the price tag and how one person made this decision for the entire city basically. And then there's people like myself who find them equally upsetting. But it turns out it actually goes directly to one of the core questions in the case, purpose. The more the justices focused on who selected the statues and how they were commissioned, what language appeared in the contract, and whether there was any broader public or artistic review process, the more the discussion shifted away from the abstract debates about religion in public life and toward the specific decisions the mayor made here. In other words, the procurement trail itself may help the court decide whether these statues were primarily civic symbols or intentionally religious ones from the very beginning. Intentionally religious ones that were trying to cloak with some self-serving reasoning.
Interesting case, but I'm not sure what the upshot of all this is for the Article 3 question, because even if to our colloquy earlier about the affidavit, assume that the judge did dismiss the affidavit in whatever way that this court would defer to. I'm not sure that's correct, but you're still left with, do these statues do they serve secular purposes as a general matter? That's what the COLO question is. The COLO question is not what was in the head of the people who crafted that statute, that legislative chaplaincy statute, here selected these statues. Instead, it's do these statues serve secular purposes generally? And I think the answer is yes, based on what the firefighters and the police officers have told you. And I really think you would have to do one of two things in order to rule against Quincy here. I think you'd have to either say, number one, the firefighters and the police officers are just wrong, and that these statutes really are just religious.
Well, is that really the aperture, though, or is it what's in front of what was in front of Judge Sullivan? What Judge Sullivan's decision is based on is what we're looking at. Do you have all of that in front of him?
Well, he did, Your Honor. So he had he had one out of the four amicus briefs that I was running down earlier, but he also had all the evidence that underlies those amicus briefs. The city put in evidence about the Floridian cross in fire department logos.
Can I ask you how we measure the perception on the secular part of it? So if a citizen of Quincy is driving down the road and sees it, and they see this big angel smiting a demon, and someone has to explain to them, oh, that's actually the symbol. That's St. Michael. It's the symbol of good versus evil in police departments. Isn't that kind of a niche explanation that when you see this immediately, it strikes as overwhelmingly religious?
Well, Your Honor,
You have to crane to see that St. Florian is actually holding a pitcher of water, right?
Yeah. I mean, I'm not so sure. I think Moses holding the Ten Commandments strikes most people as religious. I think this kind of gets into the issues with this sort of objective observer. Is this endorsing religion? Is this not kind of test? I mean, plaintiffs really want, they've got like a Goldilocks objective observer. It's somebody that doesn't know too much about these statutes in order to know that they are the symbols of firefighters and police officers. Also doesn't know too little.
Well, think about the person who's driving to Roxy's to get their bargain meat, right?
I'm not sure that person knows who these figures are, Your Honor. I think that's kind of
the second one doesn't look religious, right? It looks like a Roman soldier.
It looks like a Roman soldier, Your Honor. And I don't think there's any kind of no angel rule either, right? There's a famous angel in Central Park in New York City. There's an angel in the Boston Public Garden. I think all this discussion gets at kind of the uncertainties of their test. And this is not a question that Colo asked, right? If you look at how Colo approached the effects part of the analysis, or at least what it called that, it didn't ask, would an objective observer view these prayers as endorsing religion? Again, kind of a strange question. Instead, it said, are these prayers likely to meaningfully change people's religious practices? It said no, because this, unlike in a school, right? This is in a legislative chamber. It's not a pedagogical context. It's not a place where the whole point is to influence impressionable school children. I would say that the public safety building is a lot more like a legislative chamber than it is like a school. So if you use Colo's analysis, not necessarily what it invoked as the criteria or the guidelines, which, as Justice Kafker said, were at that time the Lemon test. There was, of course, a federal establishment clause claim in Colo in a way that there's not here. If you use its analysis, that analysis is fully binding. We're comfortable with it, and I think it cuts strongly in favor of the city in this case.
Thank you.
Thank you, Your Honor.